Hi, welcome to Immigration Law for Human Resources Managers and Employees. I'm Carol Brown, the Managing Attorney of World One Law Group, and this is recorded on November 20th, 2022. So who am I? I have over 20 years of experience as an immigration attorney. I earned a master's degree in public policy from Harvard University at the Kennedy School of Government, and I have my law degree from Yale Law School. And I've been the managing attorney for World One Law Group for 10 years. World One Law Group is an immigration law firm located in Bellevue, Washington. We handle visitors, business and investor visas, permanent residency, family petitions, and many more. Today we're going to talk about why immigration matters. We'll talk about the Form I-9 employment verification, business visitors and visa stamps, work visas like H-1Bs, TNs, L-1s, and others. We're going to talk about various routes for the permanent residency or green cards, and we're going to answer some questions that you might have. First, we'll talk about why immigration matters, and we'll look at the big picture for businesses. Immigration companies want to recruit global talent. They want to hire foreign graduates from major universities, recruit employees of competitor companies, transfer employees at affiliates abroad, and find people with special skills to fill jobs here in the United States. Immigration attorneys can help screen potential employees, file petitions for visas and work authorization. We can help apply for permanent residency or U.S. citizenship. We can also answer questions directly from you, the human resources manager or employee, as well as your company's employees. And we can keep you informed about changes in law and policy. The first thing we want to talk about today is the Form I-9. It's the Employment Authorization Eligibility Form, and it's probably the way most HR people interact with the U.S. Immigration Service. The Form I-9 requires employers to verify identity and work authorization for all employees. If an employer provides a document from List A, it proves both identity and work authorization. They provide List B and List C documents that also proves identity with List B, and List C proves their work authorization. So they have to provide one of each of those documents. That Form I-9 must be completed within 3 days of the employee starting the job. You have to retain those Form I-9 records for 3 years after the date of hire or 1 year after the employment ends, whichever date is later. These I-9 records must be stored away from personnel records because the Department of Labor or U.S. Immigration Service may audit them. For information about how to complete this very important form, you can go to the USCIS Handbook for Employers, also called the M274. So we have a trivia question. The Form I-9 is 2 pages long. How long is the handbook explaining to employers how to complete this form correctly? The answer, 32 pages of instructions for completing a 2-page form. Many workers in the United States don't have permission to work legally in the United States. And it is illegal for a U.S. employer to knowingly employ an alien without permission to work. Violators may be fined or even imprisoned for serious violations. That first offense, you may be fined up to $2,000. And if there's a crime, if there's a pattern or practice of hiring, it may also be a crime if there's a pattern or practice of hiring illegal workers by your company. That can increase the fine up to $3,000 per illegal alien that is working, with a maximum jail time of up to 5 years. Note that you're not required to check the immigration status or complete a Form I-9 for vendors and contractors of your company. There are many undocumented workers currently in the United States, and they tend to gather at certain types of industries tend to attract individuals who don't have work authorization. Those include The occupations with high levels of undocumented workers include maids and housekeepers, construction laborers, cooks, restaurant workers, ground maintenance workers, janitors, carpenters, and agricultural workers. The next step, we're going to talk about visas for visitors, including the B1 and B2 visitor visas, as well as the visa waiver program. Generally, most foreigners need permission or a visa stamp to enter the United States. Visas allow foreign citizens to request entry to the USA. Visas do not guarantee that admission. You can see from this photo that there are many different things that you can learn from just a copy of the visa, including a photograph, that individual's port where they obtained the visa, their first and last name, their passport number, the issue date, the expiration date, and any sort of special recognitions or limitations on that visa would be printed on this text. You may also find out the type of visa that they're allowed, the type of status that they've been approved for, and whether it's a multiple entry or a single entry. Business visitors are a B1 visitor visa for business. It allows entry into the United States temporarily for business purposes. And you must intend to return back to your home country to qualify for this type of visa. You can be paid by a foreign company for this visit to the United States, but you cannot work for any U.S. employer in this status. Visitors have certain do's and don'ts, or things that they're allowed to do and things that they're not allowed to do. A visitor visa on a B1 or B2 are allowed to Visitors on a B1 or B2 visa are allowed to attend meetings, solicit sales, take orders, attend conferences, go to interviews, set up a U.S. office, do research, or make investments. What they're not allowed to do are get a salary or income from a U.S. company, study at the university, get paid professional performances, work in foreign media, or overstay their visa. The business visa requires a showing of non-immigrant intent. U.S. law actually presumes every visitor around the world wants to stay forever in the United States. To overcome that presumption, you must show that your purpose is business, pleasure, or medical treatment, that you're coming for a specific limited period, you have the funds to cover your expenses in the United States, you have social and economic ties abroad, you have a residence outside the United States, and you're likely to return home after your visit. Some countries are more likely to be refused a U.S. visitor visa. The visitor rejection rates show the dark green with a 5% loss of 5% or the blue visas. The darker the green is less. The darker green shows a less likely chance of being rejected for your visa application, whereas the highly red, the countries shown in red show a very high rate of refusal for issuing a visitor visa. Those countries that are indicated in blue indicate a visa waiver country or a special case, like Canada, Western Europe, and Australia. The visa waiver program allows certain countries with low rates of problems with U.S. visa applications can come to the United States on the visa waiver program. These visits must be for 90 days or less. There can be no extensions or changes of status allowed. And you can enter the United States without a visa, but you have to be from certain countries. That includes Western Europe, Japan, and Australia. Canadians are a special case even than other visa waiver countries because they are visa exempt by law. Visa waiver countries that allow visits for 90 days include all of these countries shown. Now let's talk about temporary work visas, including the H-1B, the TN, the L-1, and the O-1 visa status. Temporary work visas generally are required to be employed in the United States, and most require a job offer from a U.S. employer. These work visas tend to be valid between 1 and 3 years, and some are renewable for a certain period of time. Many of these visas allow what's called dual intent, that allow the individual to apply for permanent residency without losing their work visa. The usual process is to petition to the U.S. Citizenship and Immigration Services. Once approved, that individual can apply for a visa at the U.S. Embassy or consulate abroad, or begin work if they're in the United States. Work visas tend to look like an alphabet soup. F1s, H1Bs, J1s, L1s, O1s, TNs. It looks like a crazy new language, but each of these visa types mean a specific type of eligibility and certain limitations. We'll go over each one of these types of visas. The first visa that you want to be aware of are student visas, and there are 3 categories of student visas. The first and most common is an F1 student visa. The second is a J1 visa used for training and studying. And the third are M1 visas, generally used in vocational and technical training. Certain students on these various types of visas may get work authorization. Curricular practical training are the kind of work authorization a student gets while still in school, and it's coordinated through the school or university. A student should be aware to use less than 1 year of full-time curricular practical training. Students should use less than 1 year of their curricular practical training, or they may lose the opportunity to earn their optional practical training. Optional practical training, or OPT, is the type of work authorization that exists after graduation. Only if the student used less than 1 year of CPT, they would have to petition the U.S. Immigration Service for the Employment Authorization Document, also called an EAD, and it gives them up to 1 year of work authorization after their graduation from a U.S. university. That work authorization can be extended for 2 years if that person had a degree in a STEM field, or science, technology, engineering, or mathematics from a U.S. university. H-1B professionals are for people in a specialty occupation. What's a specialty occupation? The job is required to have at least a bachelor's degree in a specialized field, and the individual has a U.S. bachelor's or the equivalent. The employer must pay the prevailing wage, providing the same working conditions as the U.S. worker. Those H-1B visas are generally valid for 3 years, and they may be extended for up to 6 years in the United States on an H-1B. The problem with the H-1B visa is the dreaded H-1B visa cap. Congress, in its infinite wisdom, only allows 65,000 H-1B visas for the entire country for the entire year. They added an additional 20,000 H-1B visas for the so-called master's cap for individuals who graduated with a master's, PhD, or other higher degree, advanced degree from a U.S. university. All new visas in the last several years were gone within days of all new H-1B visas for the last several years were gone in days of them being available. And new visas become available on April 1st for an October 1st hire. The H-1B cap lottery process has changed recently. An online registration process was announced for fiscal year 2021. Instead of filing a whole new H-1B petition and hoping it gets picked in the lottery, now there is an online registration process that costs only $10 per individual that is registered by a company for an H-1B visa. You'd only file a full H-1B petition if you're selected for the cap, and it increased the number of filings by tens of thousands because it's a huge money saver. The registration period for the H-1B lottery starts in March, and I recommend registering anyone you might want to hire in the coming year. That includes students on their optional practical training period, if you want to continue to have them work for you, anyone on a TN visa who may eventually want to get their green card, as well as any new hires you want to bring onto the company who don't already have an H-1B visa. The U.S. Citizenship and Immigration Services, or USCIS, will select the H-1B lottery at the end of March and begin informing employers at the end of March and beginning of April. There's also a special visa called an H-1B1 for citizens of Chile and Singapore. Those are based on free trade agreements that the United States has with Chile and Singapore, and it provides special visas for these citizens that avoids the H-1B cap and the lottery process. These visas have much the same kind of requirements as the H-1B, except bachelor's degrees are not required for certain occupations. The H-1B1 provides for 1-year terms, but it's renewable indefinitely. However, individuals with an H-1B1 may not apply for permanent residency from this visa. The L-1 visa provides for transferees of multinational companies from companies affiliated with you abroad to your U.S. operations. You must show that the individual was employed in a foreign country for at least 1 year of the last 3 by an affiliate, parent, or subsidiary to the U.S. company. The L-1 is valid for generally 3 years and then is renewable for 2-year increments. And there are no annual limits on the number of visas. Spouses also have automatic work authorization. You have to meet certain criteria for your employee to be able to use this type of visa. L-1As are available for executives and managers of your organization if they manage people or a function of the organization. This type of visa is renewable for up to 7 years total. The L-1B visa is for specialized knowledge employees who have proprietary or difficult to transfer knowledge of products, processes, or procedures of your company. This L-1B visa is renewable for up to 5 years. The TN visa is available to Canadians and Mexicans and was created initially by the North American Free Trade Agreement, or NAFTA. The TN visa is available for 3 years and is renewable indefinitely, but you must intend to leave the United States. There are restrictions on filing for permanent residency while on a TN visa. An individual on a TN visa must work in a professional occupation that is listed in the NAFTA treaty and the updated USMCA and meet certain job requirements. These occupations include things like an accountant, architect, biologist, computer systems analyst, engineer, graphic designer, lawyer, nurse, occupational therapist, physical therapist, and veterinarians. The next visa we're going to consider is the O-1 Extraordinary Ability Visa. These visas are available for individuals with extraordinary ability in the sciences, arts, education, business, or athletics. Individuals with the O-1 visa must show sustained national or international acclaim or extraordinary achievement in their field. This can be shown by a one-time big prize like an Emmy or a Tony or an Oscar, but if you don't have one of those big prizes, you can still meet 3 of the 10 requirements or criteria to show an O-1 visa. Things like other lower level international or national awards, people publishing material about your work, being a member in an association that requires outstanding achievement, being a member in an association that requires outstanding achievement, making original scientific, scholarly, or business contributions of major significance, authoring scholarly articles published in a major media, having a high salary or compensation, serving as a judge of the other's work, or past employment for organizations with a distinguished or high reputation. You must show that you're performing temporary services for a U.S. employer or an agent in the U.S. if you're going to be working for multiple entities or companies. The O-1 visa can be valid for 3 years and is renewable in 1-year increments. The J-1 exchange visitor promotes the interchange of persons, knowledge, and skills in education. The J-1 exchange visitor promotes the interchange of persons, knowledge, and skills in education, arts, and sciences. It requires sponsorship through a U.S. State Department program. Spouses and children of this type of visa may get work authorization. The J-1 visa status is available for many different occupations and areas, including college students, college professors, medical residents, au pairs, trainees in businesses, school teachers, research scholars, and even camp counselors. Let's talk about permanent residency, or getting to the green card. Permanent residency is also known as a green card in the United States. Permanent residents are allowed to live and work in the U.S. permanently. Permanent residents have the same rights as U.S. citizens, except they cannot vote, they may be deported for certain types of crimes, and they may lose their green card or permanent residency status if they remain outside of the United States for more than 6 months without filing additional documentation to save their place. Permanent residents may obtain a green card based on employment, based on their family relationships. They may be approved for political asylum, or they may qualify under the visa lottery program. Employment-based green cards generally follow. Employment-based green cards may be based on many different types of occupations and eligibility. The labor certification process, or PERM application, is the most common way, but certain high achievers like aliens of extraordinary ability, outstanding professors or researchers, or national interest waivers may bypass that PERM labor certification process. Certain other occupations may also qualify for special fast-track processing. These include multinational executives and managers, nurses and physical therapists, and doctors. The most common way is labor certification, or also known as the PERM process. In this process, the employer must prove that there are no minimally qualified U.S. workers for the position. The requirements for a labor certification require a full-time, permanent job offer, reasonable job requirements, they must pay at least the prevailing wage or actual wage, and they must do recruitment in newspapers, state employment departments, and other ads for professional occupations. This PERM labor certification is certified by the U.S. Department of Labor through an online application. Once approved, the employer files the I-140 petition with the U.S. Immigration Service, and then the employee applies for permanent residency when a visa is available. That can include the I-45 application, also known as an adjustment application, or that individual might consular process if they're not eligible for adjustment status or if they're not in the United States. So the basic process is PERM labor certification, then the I-140 immigrant petition, and then the green card of the I-45 or consular process. Aliens of extraordinary ability also have a fast track for permanent residency through their employment. They could show that they've won a Nobel Prize, an Oscar, or other international award, or again, meet 3 of the same criteria of extraordinary ability, as was described in the O-1 visa by the same name. Multinational executives or managers also have a fast track towards a green card. They must meet certain requirements and show that they've worked at least 1 year in another country with a parent, subsidiary, or affiliate of the U.S. company. They must be in an executive or managerial position and be transferring to a permanent executive or manager position in the United States. This kind of application does not require labor certification. They can skip that PERM process and file the I-140 petition directly. These requirements are similar to the requirements for the L-1A work visa. The National Interest Waiver also provides a way of bypassing that PERM labor certification if the work of that individual benefits the national interests of the United States. The work must be proven to have substantial intrinsic merit. The benefits of the work must be shown to be national in scope, and the past record of achievement must demonstrate that the national interest is benefited to a substantially greater degree than would an available U.S. worker having the same minimum qualifications. So basically, you have to demonstrate that not only is your work important, but that the way you as an individual do the work is better than the average available U.S. worker with the same kind of qualifications. World One Law Group, I wanted to Lastly, I wanted to describe World One Law Group and provide an overview of our services. We provide business immigration help, including H-1Bs, L-1As, TNs, E-1s, O-1s, as well as various routes for permanent residency. We help with family immigration, including petitions for spouses, children, and parents, both through the adjustment of status process and through consular processing. We also help individuals with the naturalization applications once they've been a permanent resident for 5 years or 3 years if they're married to a U.S. citizen. We provide corporate policies and strategies, including employee handbooks and policies, regulatory compliance, recruitment of foreign nationals, I-9 audits, E-Verify strategy, short and long-term planning about immigration, and advice during corporate layoffs. We also help employees with their visa applications, including embassy processing for visa stamps, visitor visas to attend trainings, meetings, and other activities, as well as assistance with the visa waiver program. We also do other kinds of cases, including deferred action for childhood arrivals or DACA, asylum and refugee applications, as well as other kinds of visitor visas. We do provide comprehensive management of our immigration cases, including an individual customized case assessment and strategy every time. We prepare and file forms and supporting documentations for petitions and applications. We serve as a resource for your HR management department as well as your HR team and employees. And we provide an opportunity to track the progress of cases electronically and be informed, the company and employees, of your status updates and processes. Our online case management system provides electronic questionnaires for employees and prospective employees and HR reporting and case status company-wide. That online case management system is available 24/7, and those questionnaires and reports are available in multiple languages. We offer proactive monitoring of the expiration dates for visas, passports, and other status. We also provide personal assistance with immigration, including visa stamping, transferring employees, family immigration issues, and access directly to attorneys to answer important questions from your employees. We also provide translations of documents from Spanish and Mandarin, as well as notary public services. Our fee structures offer flat fee services for the most common types of cases in our immigration cases. We offer non-immigrant visa petitions like the H-1B, L-1A, TN, O-1, E-1, and E-2s. We provide perm labor certification applications, I-140s in various different types, as well as the I-45 adjustment of status applications for permanent residency. We offer hourly services in certain rare circumstances or unusual cases, and we do charge hourly for requests for evidences from the U.S. Immigration Service or Department of Labor audits. We also provide hourly services for corporate planning and strategy, as well as our training and webinars. You can see our fee list on our website for more detailed information about our legal fees and our filing fees. The benefits of partnership between your company and World One Law Group includes access to attorneys for immigration questions. We offer timely responses by email and in some cases by Zoom or Teams link. We also do efficient and effective case preparation using technology effectively, and we provide electronic updates throughout the life of the case. We offer expiration date tracking for your employees, and we make sure that you remain in compliance with Department of Labor and USCIS regulations. We'll help your company develop immigration policies and procedures and provide consulting on short and long-term planning about immigration needs. For your employees, they'll get the personal assistance with their immigration questions that they need by Zoom, phone, email, and sometimes with personal meetings in our office in Bellevue when the COVID pandemic subsides. We provide information electronically 24/7 so people can be at ease about where the status of their case is. Those case status updates are available online all the time. People can review and revise their forms electronically, and we also provide ongoing assistance beyond the approval of their petition with visa stamping, correcting I-94 issues at the border, and also with issues about family immigration and work authorization. If you'd like to work with World One Law Group, we would love to work with you. The first step is to schedule a free consultation where you can review and sign a representation agreement. You would then provide a list of your employees on the visas, such as their name, their job title, salary, email address, and any copies of their previous immigration documentation. We can also request this from your existing immigration attorney. When you're ready to file new visas for your employees, we'll send a link to an online questionnaire that employees can complete online. Once it's complete, we will prepare their forms and support documentation, review and revise the forms, arrange for signature from you and potentially them, and then file that petition with the U.S. Immigration Service. If you have questions that you would like us to answer in future videos, contact World One Law Group. Our phone number is 425-250-8110, or you could email me directly at Carol, it's Karol, at world1law.com. That is WORLD, the number 1, LAW.com. Thank you.